So I will in a moment share my screen, and what I would like today to do today is to really introduce you to a research project that has started already in 2019 and it's still ongoing. It's about how can we better understand the causal link between greenhouse gas emissions and causation in the laws. And I appreciate that there are some in the audience who maybe haven't been as familiar with these issues. So I will introduce you to some of the leading landmark climate cases and explain how courts there have approached causation, how they have contributed to a normative setting that makes it easier than hopefully for other courts to creatively use the law to follow and trace the science that we have, and that is, as you know, firming further on climate change. So this will be a session really very much focusing on courts' decisions, on litigation, but also on the intersection of science and law. And I hope that will give you some further insights into some cases. I mean, last year we've heard really interesting parts about or other parts of the world where interesting litigation has happened, including in Africa. And I think it's really, really beneficial to attend these sessions just for that reason, because these are people who have the experience in their professional life with these cases, and they have also led the decision making in those cases. So let me share my screen, and anytime you've got a question or anything, please just let me know, and we can have a discussion anytime. So it doesn't have to be just me talking for the whole time, but if I don't hear anything, I will speak probably until 35, and then hopefully we can have a few questions and answers then. So again, and thank you so much for coming. I really appreciate everyone is busy, and 9 o'clock is early, so it's fantastic actually to have you here. And we will also record the session and make it available. Now, the overview for the session today is I would like to start with some causal explanations and climate litigation as a limited success story. So what happened so far? How have courts approached general causation and specific causation, and then attribution, because these are three distinct concepts. And then also looking into the second part, the potential of attribution science, which is almost a subfield of climate science, for the legal concepts of causation and attribution. So where are we at the moment? And this is also part of a chapter that I'm writing for a book project that is led by the World Commission on Environmental Law, where I'm asked to look into how courts have used especially attribution in a litigation scenario. So have they acknowledged that there is attribution science? Have they acknowledged that there is more to this link between one extreme climate impact, one extreme weather event, for example, and a certain emitting region, or even a certain emitter? And we will come to one case in particular that is currently still pending. It's almost a very political case now, and I will explain more on that. It's a really interesting scenario. Now, and then finally, I would like to come back to the more theoretical contribution of this research in terms of what do we add to the existing literature here. And so what we are doing is we have already published one article on developing a new matrix for causal analysis, and now we're trying to refine this approach and make it maybe easier for those who maybe could apply it. So that is to say, you know, courts, judges, to grasp this concept that we have in mind, because it is sometimes very difficult to explain it in a certain case scenario. So it's one thing to have this abstract theory, but then how do we bring it back to the application level? Just can see somebody has enabled closed captioning, which is fine. No objection to that. So to start with the first part, now, where are we at in terms of the Paris Agreement even? Is there something where we can say the Paris Agreement acknowledges a causal link? Now, the Paris Agreement does actually have a provision in Article 8.1 that recognizes the importance of averting, minimizing, and addressing loss and damage associated with the effects of climate change including extreme weather events. So there we've got some framing of our causal issue. So there is the recognition of the importance of addressing loss and damage, and these are associated with climate change, and these events include extreme weather events. Now, of course, the language here is important. It doesn't spell out the word causation in any shape or form, of course, but we can see that there is some acknowledgement that these two come together. We've got climate change, increasing greenhouse gas emissions, as we know, and then also these extreme weather events happening more frequently and more severely. And this has been acknowledged in further COP decisions under the Paris Agreement, including and very specifically in COP26, which happened in Glasgow. Now, courts on that basis and on the basis of national law in particular have discussed the consequences of climate variability generally, so in a way of accepting that certain projects can lead to further climate change, or that further greenhouse gas emissions from projects will lead to more severe impacts. So this is a general framing of the causal issue. So they've accepted the notion that climate change is increasing the frequency and severity of extreme weather events. What is more difficult is to establish the specific causal link between the one event and a certain emitter, or what is also difficult, establishing causation between one event and the general increase in greenhouse gas emissions. So these two are, of course, connected, and these tests for the causal analysis are generally the general but-for and conditio sine qua non test. So this is what I explain now here. So I would call it a limited success story so far. We've got some courts who found causation, others found it, but then the case maybe didn't make it in other terms, or it didn't jump over other hurdles. For the admissibility of the case, for example, Juliana, we will come to that, is one of those. Now, one of these main obstacles for claimants is to establish causation, and this already plays a role in the admissibility of the case. So some cases won't even go to the merits phase simply because they cannot jump over all the hurdles of at least establishing a prima facie link for causation for the admissibility hurdle. So even not at first glance, there's no causal link. That's what some courts find. Now, however, what is generally acknowledged is this link that Article 8 of the Paris Agreement indicates, this link between the increasing greenhouse gas emissions, global mean temperature increase, and in general increase in intensity and frequency of climate change impacts. But that is not enough to establish causation in many cases, and especially in those cases where we are looking back. We're looking back to a situation that has arisen because of climate change. We have an impact, and now we want to have, for example, compensation for this impact. So therefore, we need in these situations a concrete link between this climate impact and the respondent, which might be a group of states or even a specific emitter. And this has been in the past very difficult to establish also in climate science, but there has been some progress. Now, the hurdles of these legal tests, in addition to the science not being there in some situations, are relatively high because we are asking but for and conditio sine qua non. So we are asking, would this event have happened but for the factor that we think led to it? And often there is no single causation, no single chain of causal events, but you have multiple factors, and it's very difficult then to establish that the event would not have happened without one event, especially climate change, because there are also natural developments or natural climate variability that can lead to certain hazards and climate extremes. Now, I give you one example of a case that did not proceed to the merit stage. It failed the admissibility hurdle, but not the causation standard. And that is quite interesting. So we also have cases that can be a success story on causation, but still haven't made it to further stages in the investigation. Now, in Juliana in the United States, and there were many decisions in that. So as you probably followed this, if you're interested in this field and have seen, this is also a very political case. So the core of the case was that the plaintiffs allege that the injuries that they suffered are caused by carbon emissions from fossil fuel production, extraction, and transportation. So they claim there is a causal link. And here the Circuit Court acknowledged that a significant portion of those emissions occur in these countries, so in the United States, stating that these emissions accounted for 25% of worldwide emissions from 1850 to 2012, and currently accounted for, or at that time of the decision, for 15%. So they even looked into the historic emissions as well. And they cited a case which was decided very early in 2007, Massachusetts and EPA, again, a very famous landmark case in climate litigation, where the court had, the Supreme Court of the United States had found that even 6% of the worldwide total of emissions, and these were the emissions that were just caused by motor vehicles, and this case was about the regulation of emission standards for these motor vehicles, were already a cause of the alleged injury by any standard. So it doesn't have to be in the double figures, even 6%, it's over the threshold of a factor that can count as a cause. Yeah. So this ties in with the wider discussion of, will any contribution of us be a causal factor for climate change? Yes, we know in some sense it is, but it's also a question of, can we detect it? And this is what this attribution science is doing. So there are measurements in place that ensure that only those significant factors, or those contributions that are above a certain threshold, will count as the cause. Now, the court was then also satisfied that the plaintiff's evidence shows that these federal subsidies that were also in question here, and the leases have increased those emissions. But then in the end, the court failed to surpass the hurdle of redressability. So the court found that it was not in a position to give claimants the satisfaction that they needed, because it was not in a position to replace, so to speak, the Congress to legislate on this matter. So it's a question of balancing of powers here. It's the court who says, well, we are restrained, we can't really provide a remedy. It's not within our powers. Now, another court where we have a very recent decision on causation was the case in Notre Dame versus France, that is from 2021, so a very young case. And here the Paris Administrative Court first ordered the state to disclose its measures to meet its climate targets, because it was asked to find whether or not the French government was exceeding the limits that it had set for itself for the greenhouse gas emission targets. Now, the court then found that France had emitted 62 million extra tons of greenhouse gas emissions between a certain time, in a certain time period. And the court ordered the state to take immediate actions to comply with its commitments to reduce its greenhouse gas emissions and to repair the damage. And this is very interesting, because the court here applied a provision of the French Civil Code in the relationship to the government. So it's almost transcending these private public law division, where we see even the state can fulfill the criteria of a provision of the civil code that say that every person is responsible for an ecological damage and must repair this damage. So again, this is the framing of our causal issue, because the court has recognized that by exceeding a certain amount of greenhouse gas emissions, the government allowed a situation to develop where ecological damage occurred, and it had to repair this damage. So again, it doesn't help us with the specific causation, but it links exceeding emission targets with the at least increased likelihood of climate damage, or damages caused by climate change. Now, an interesting, now not a national court, but a domestic committee under the Convention on the Rights of the child has had to answer the question whether or not certain states that had committed and ratified this convention had violated provisions on protecting the rights of children in the context of climate change. And this is very interesting because it was another case where the court really established causation step by step. It then found in the end that this case was not admissible because national remedies had not been exhausted. Now, the court started by saying that the collective nature of causation of climate change does not absolve the state party of its individual responsibility that may derive from the harm that the emissions originating within its territory may cause to children, whatever their location. And that is really interesting because it means that we can set a causal factor in one territory, and this may affect children outside the territory. So we see the extraterritorial application of causation here as well. So it's not limited to the state's own territory. These causes, these injuries can occur also outside the territory. The committee also found that the harm was foreseeable. It was significant, which must be more than detectable, but less than serious or substantial. And again, that is very important in this development of the jurisprudence towards where do we have a measurable contribution. It doesn't have to be serious or substantial according to the committee decision. It is sufficient to be just detectable, which is probably above the de minimis threshold, which is a generally acknowledged threshold in the law. Now, the committee then also found that a causal link existed between the transboundary harm and the state on whose territory the emissions originate, but then found also that national remedies have to be exhausted first. Now, so another interesting case is a national case, one I'm more familiar with because I've written an article on this one, on the advanced interference-like effect of climate targets. It's a really interesting case that was brought by Luisa Neubauer against Germany to claim that the 2019 Climate Protection Act was partly unconstitutional because it didn't foresee enough or stringent targets up to 2030 and certainly not after 2030. So the Climate Protection Act at that time only set out certain climate targets in terms of reduction targets until 2030, but not for the time afterwards. And the court found that, first of all, the protection of life and physical integrity under Article 2.2 encompasses the protection against impairments of constitutionally guaranteed interests caused by environmental pollution, regardless of who or what circumstances are the cause. So in other terms, it is acknowledged with this that climate change can set a cause for an impairment of a constitutionally protected right. In this case, it is Article 2.2, which is health and the physical integrity. So this can be affected by the consequences of climate change. There's a constitutional provision that protects against that. And also this realizes that there is a causal link. If there is scientific uncertainty regarding the causal relationships of environmental relevance, a special duty of care is imposed upon the legislator by Article 20A of the Basic Law, also for the benefit of future generations. And that is really interesting because 20A of the Basic Law is a state objective, and the state objective encompasses the protection of the foundations of life for the present and for future generations. So the court here said that there is a clear instruction or mandate for the state to apply these causal tests, even if there is, or in cases where there is still scientific uncertainty, always for the benefit of the future generations. So there's a special duty of care, not just a general duty of care, there is a special duty of care. Now, in the end, the court found that the targets that were set today had an advanced interference-like effect. So they were already interfering with the rights of the future generation and therefore some of the provisions were unconstitutional, and these have since been changed. So this is a real immediate impact. There are more stringent targets now, including for after 2030, and also the net zero target has been brought forward from 2050 to 2045. That also demonstrates, my last sentence on that case, that the state has not been sufficiently ambitious beforehand when setting the targets out for the first time in the Act. So instead, the court here really had a crucial role to play in increasing and focusing the state back to being as ambitious as possible as the Paris Agreement requires. So it's a really important function of the court, and the court also said we reserve the right to supervise and supersede further legislation, and there's a dynamic obligation of the legislator to legislate in accordance with new emerging scientific evidence. Now, another interesting case is the Human Rights Committee decision on the Torres Strait Islander case, where that was a case brought under the International Convention on Civil and Political Rights, where the committee found that states have a protective duty in relation to taking adaptation measures against climate change for those people who live in this Torres Strait Islanders region. As you know, this is very close to, when you look at it between Papua New Guinea and Australia. So they claimed they were not sufficiently protected against sea level rise, which led to a deterioration of their way of life, their living standards. And here the committee concluded that there is an obligation of states parties to respect and ensure the right to life. And this extends to reasonably foreseeable threats and life-threatening situations that can result in loss of life. So that didn't have to be loss of life already. It can already be the threat of loss of life. And the committee concluded that the state, in this case Australia, had failed to discharge its positive obligation to implement adequate adaptation measures to protect the applicants' rights to home, private life and family under Article 17 of the Covenant, and also the failure to adapt timely and adequate adaptation measures was an interference under Article 27 of the Covenant to maintain that, which protects the rights of minorities, indigenous populations to maintain their traditional way of life. So again, you know, the foreseeable element brings in this causation focus. Now, this is a very interesting case, and I know that Dr. Justice Preston is in the audience, and Justice Brian Preston, who is now visiting professor in Durham Law School and with the center, has decided this landmark case on climate change, which he will best be placed to explain, of course, so I will try my very best, and he will also have the opportunity to speak to you in person because he will deliver his lecture in the lecture series in February. Now, in this case, what was at stake was a planning permission request from Open Cut Coal Mine Company, and they were seeking to overturn the denial of the request from the Planning Commission to grant them the to grant issuance of a permission to go ahead with building in this nice Gloucester Valley that you've just seen, a coal mine. Now, Justice Preston here found that the project's cumulative greenhouse gas emissions, as all greenhouse gas emissions, will contribute to the global total of greenhouse gas emissions. And these global total of greenhouse gas concentrations will affect the climate system and cause further climate impacts. And therefore, the cumulative greenhouse gas emissions, if this project would go ahead, would likely contribute to further changes of the climate system and the impacts of climate change. Now, here really clearly spelling out of the general causation link between increasing greenhouse gas emissions, the project's emissions, and the likelihood of further climate change and the associated impacts. Again, this is not a case that was concerned with attributing a damage, and this is a different scenario. But this case also contributes to the development of the case law, where we see that there's a normative framework evolving where courts have made this causal connection, and that will make it more likely in the future for other courts to come to similar conclusions. So again, here was also addressed the problem of what happens then if one country changes these policies. So what is about this carbon leakage argument? And the court found that the global problem of climate change needs to be addressed by multiple local actions to mitigate emissions by sources and remove greenhouse gases by 6. Now, one more case here is Mille Defensie, which is a case that was decided in the Netherlands against Royal Dutch Shell. And here, a causal link was found between the greenhouse gas emissions of Royal Dutch Shell and dangerous climate change. And interestingly, here, the court also found a causal link between production limitation and emission reduction. And this addresses again this carbon leakage argument. So that means that if I don't explore fossil fuel resources, then somebody else will do it. So on average, we will always see the same amount being explored. However, here the court found that studies using elasticities from the economics literature have shown that for oil, each barrel left undeveloped in one region will lead to 0.2 to 0.6 barrels not consumed globally over the longer term. And that is really crucial because it engages with these kind of causation studies that enlighten us what will happen if we don't go ahead with a certain production. And it shows that there is a causal relationship between not having further oil and gas infrastructure in place and using less. So it's not that it will be replaced elsewhere. Now, to summarize, courts acknowledge the general causation and specific causation in some cases. This causal link can be established between a country's emissions and extraterritorial harm for and of individuals. Attribution of extreme events requires specific evidence, and the link between the concrete emissions of a specific project and additional climate change impact has been recognized in some cases, as we've seen, but this does not yet include establishing liability for a concrete climate-related event. And we also have to deal with the fact in the law that scientific evidence includes probabilities of likelihoods and different levels of degrees of certainty. This is always the case. It's also the case in medical exposure cases. And there are also different confidence levels attached to scientific evidence. And these confidence levels relate to the amount of literature and certainty that has emerged based on these studies and based on the literature. So the more researchers come to similar results in their modeling and in their observations of the climate, the higher is then the confidence. Now, there is now the potential for attribution science to have a real impact for the legal concepts of causation and attribution. So in the past, there has been a claim that was unsuccessful. There was an attempt by the native village of Kivalina in the US, a case almost now a long time ago, where there was an attempt to link a severe weather event to a defendant. But it has now been further investigated whether based on today's science, there could be a link established. And some scientists claim that it is now possible, or it would have been possible now to establish a causal link even in that case. So there are studies out about that. So there has also been a turn in the literature where we see some publications coming out and claiming that attribution science can help to establish a legally relevant and causal link. Now, how would this work? And so we've tried to bridge this gap between science and the law. So we think that there is a potential to change litigation outcomes. There is the potential for climate attribution science to change the context for causal claims. Even if it doesn't lead to a specific change in an outcome of a case, it can still add to this normative framework in which causal developments or causal explanations are being made. And it can improve legislation and policy frameworks. And I think that is an under-investigated area. So stronger evidence generally allows us to allocate more clearly responsibilities and compensation in the law. Just to explain a little bit about how attribution science works. This is from the colleague I work with, Frederica Otto. Now she explains it with dices and whether or not a dice has been loaded. So she says that it is generally impossible to say this event would not have occurred without human influence, but attribution science can at least ask how the risk that this type of extreme event occurring has changed due to external factors. And this is the question of, is there something with these dice that makes a certain number coming up more often? And this is what we are doing. We are loading the dice, we are loading the climate which leads to an increasing likelihood in certain events. So possible outcomes of an attribution study can be that the event was made more likely due to anthropogenic climate change. The event was made less likely due to anthropogenic climate change. Anthropogenic climate change did not alter the frequency of occurrence of the events, or with our current understanding and tools, we cannot assess whether and how the event was influenced by anthropogenic climate change. So there are different outcomes, and the data can sometimes be or lead to surprising results where maybe the climate signal wasn't as evident as maybe researchers have thought when they started this study. But also the contrast or the opposite can be true if sometimes there is a clear evidence that this, for example, the heat wave in over Canada last year would not have happened without anthropogenic climate change. So there can also be a very, very clear indication that there is causation. So both ways are possible. Now, examples of where we have more clarity include these cases without human-caused climate change. Temperatures of 40 degrees Celsius in the UK would have been extremely unlikely, or the Western North American extreme heat virtually impossible without human-caused climate change. So again, virtually impossible, that means a lot for scientists, and we mustn't dissect it from the legal perspective and say, well, it could still be possible. This really means it's almost certain that this was caused by human-induced climate change. And the Siberian heat wave of 2020, almost impossible with human-induced climate change. So for some events, we have very robust evidence. Now, this is one case, and I just need another 3 or 4 minutes to explain this and what follows, and then we can have a few minutes for discussion. So a case that is currently pending before the Higher Court of Appeal in Hamm in Germany, where a Peruvian farmer is claiming that there is a very high risk that this glacial lake in the Andes will overflow, and this would then destroy the city of Huaraz, where he lives. And he claims that a cause of this, or one of the causes of this, are the contributions to climate change of the biggest German energy provider, RWE. Now, they're not claiming that it's only their fault. They're claiming it's a pro rata contribution of RWE's emissions. Now, the first instance court in Essen held that the contributions of RWE are among many other contributions. They applied a very strict understanding of the but-for test and said that, this would have resulted, the same risk would have been there without RWE's contribution. So there's no change, no increase in risk that can be measured. It can't be detected. So now, when you think about this, there is no coherent concept in the absence of normative parameters to establish causation in this case, or generally to some extent, and no ability to portray this increase in risk that fails in the eyes of the court, the but-for test. So we are wondering in this project, how can this be the case if we have other cases where we could establish causation, even if there was higher scientific uncertainty. So if there are these very strict causal tests applied, we have a particular problem, and we can solve this in 2 ways. Now, one way to remedy the harshness of the causal analysis is to apply normative correctives. And we've seen this in asbestos litigation or cases of hypothetical causation, where again, it wasn't clear who contributed exactly to the injury, but we knew someone along the line did. And what in these asbestos cases the courts found was that then the defendants should be jointly liable for the injury that occurred, because the person who was injured by insufficient protection against asbestos inhalation should not also suffer the consequences of the harm. So there needed to be compensation. We don't have any agreement on normative correctives so far in climate change litigation. It's occurring in some cases, but there's no coherent way yet. The other way would be to assess the logical fundamentals of the causal analysis. And this is what we've done. We have dissected the elements of the causal analysis that are at play in climate change. We call this the quantity of the emitted greenhouse gas emissions, E, the increase of global mean surface temperature, T, the impacts of a changing climate consisting of a general tendency of increasing frequency and severity of some weather events and climate-related slow onset events. We call these the distinctive causal field. And that means like all heat waves in Europe, for example. So if we've got one heat wave in Europe, we can compare it with the distinctive causal field and establish whether the heat wave has the same pattern, is very similar to our causal field. And then we've got against this backdrop, IS, the occurrence of a concrete climate change impact, either as a severe weather event or as a slow onset event. Now, we then investigated how do we establish in our thinking, or based on a logical way of addressing causal dilemmas, how do we establish causation? And we generally only use two logical fundamentals. We ask whether a condition is necessary or sufficient. And that is something you may have heard, even in formal logic and mathematics, even in high school, where you always have these two conditions to prove something in a mathematical way. So we are here using some reform proposals that have actually transcended from the sciences into the field of the social sciences and into the law, a study by Judea Pearl, where he found that we actually need sustenance as a third factor. And sustenance allows us to measure the capacity of the cause to protect or maintain the effect under structural changes in the model. So whatever happens elsewhere, this one factor will still be a causal contributing factor. So it's a concurrent factor among other factors, or in a set of conditions that lead to the outcome. And that is something that the law often does already. So it's not that we are changing the entire causal analysis. We are just dissecting it and taking it apart, so to say, to see what exactly are we doing in form of a mental operation based on these logical fundamentals. And then this comes together as a matrix which has third pillars, and really only in the third pillar we see something where the game is changed because we are using sustenance. So between the emissions and the temperature, we know there is a causal link. We can use necessity and sufficiency between emissions and temperature increase, and courts have done that. Between emissions and the distinctive causal field, we can also establish a strong causal link, and that has to do with the transitivity theory. It's again derived from mathematics. So if you've got a causal link between A and B and C, then you also have the same causal connection over a set of variables between A and C. So if we've got causation between emissions, temperature, and the distinct causal field, we also have a causal link between emissions and the distinct causal field. Now, then we come to the third pillar. So how do we now establish that we have also these concrete climate impact caused by E? Is E a cause of IS? And that is where this probabilistic event attribution can explain, in some settings, a scientific link between E and IS. And the way to connect that with the law is using this logical fundamental of sustenance, where we say, well, this is an aspect that, E is a factor that maintains or produces this outcome. regardless of what happens elsewhere, regardless of natural variations in the climate, this increase in emissions is a contributing factor. And I think this has the potential to really change the outcomes of climate litigation. Just to conclude, there is some certainty in this field on causal explanations. There's a general causal link, sometimes a specific causal link. And this new causal matrix, I think, would allow for a coherent causal explanation in the climate change context and beyond, because it captures the probabilistic increase in risk. And it entails making some already existing steps in the causal analysis more explicit. So thank you very much. And I think, we can on that basis maybe discuss what we think about the climate litigation. It is a driver recognized within the UN advocacy process now. And I think we can use legal concepts creatively to enable or prevent climate protection. Now, thank you very much for listening.